The conduct of an arbitration is a collaboration of work among the parties, their counsel, and the members of the arbitral tribunal. Among all the participants of the arbitration, the arbitral tribunal is vested with the power by the parties and by the arbitration rules to manage the procedure of the arbitration in order to conduct the arbitration in a fair and efficient manner. And within the arbitral tribunal, the chair arbitrator is often the one that acts on behalf of the arbitral tribunal in the management of the entire procedure, such as correspondence with the parties, coordination among the members of the arbitral tribunal, and rendering procedural decisions in the name of the arbitral tribunal. So here we need to stress 2 points. The first one is the arbitral tribunal, they have discretionary power in managing the procedure. And the second is they pursue the values of fairness and efficiency in their exercising of their discretionary power. So in this respect, Article 17.1 of the Uncentralized Rules provides that the arbitral tribunal may conduct the arbitration as it considers appropriate, provided that the parties are treated with equality and that each party is given a reasonable opportunity to present its case. And the arbitral tribunal shall conduct the proceeding so as to avoid unnecessary delay and expenses and to provide a fair and efficient process for resolving disputes. So notably, these basic principles of fairness, efficiency, and cost-effective are well embedded in most prevailing institution rules, such as the ICC rules, which provides in Article 22, Paragraph 1, that the arbitral tribunal and the parties shall make every effort to conduct the arbitration in an expeditious and cost-effective manner. And in Paragraph 4, that the arbitral tribunal shall act fairly and impartially and shall ensure that each party has a reasonable opportunity to present its case. In the pursuit of these values, in reality, upon consultation with the parties, many arbitral tribunals, they often adopt procedural management techniques or methods aiming at saving cost, promoting and ensuring equality in allowing each party to present their cases. Such procedure management techniques or methods could include, for instance, case management conference to be held right after formation of the arbitral tribunal, or narrowing down contentious issues for party submission and for the tribunal's decision at an early stage, or parties' joint preparation of hearing bundles, chronology, or experts meeting in order to define common ground and also differences between experts so that experts could reduce their time preparing lengthy and expensive expert reports, etc. and etc. Also, in deciding how many rounds of written submissions the parties should make and by which timeline, the tribunal is always mandated to offer each party equal opportunity and approximately equal duration for preparation of their submissions. Notably, it is prevailing view, especially under common law practice, that the party who files a motion or a pleading should have the last say of the subject matter. Therefore, in developing the rounds of parties' written submissions, the claimant is likely to have perhaps 2 rounds of submission on its claims, while the respondent is likely to have 1 round of submission on its defense to the claims. And similarly, for the respondent's counterclaims, the respondent is likely to have 2 rounds of submissions, while the claimants have 1 round of defense to these counterclaims. Of course, there is no fixed rule, and the arbitral tribunal always has the power to deviate from the common practice. This is particularly true when the arbitral tribunal members and the counsel of the parties, if they come from different legal backgrounds. But still, when making a procedural management decision or arrangement, the tribunal members should always be minded to first consult with the parties in advance, and second, they should largely defer to the parties if there has been agreement reached between the claimant and the respondent. And third, they should try to accommodate the parties' legitimate requirements, such as those requirements for postponement or change of a prefixed timeline, as long as these requests appear reasonable, genuine, and are made in good faith.